Hello everyone. In today's video, I'll be discussing about right to freedom of religion, which is from Article 25 to 28. So let's start with the discussion. The Dalai Lama once said that India has a great heritage and it is a model for religious harmony where people of different religions live peacefully and in harmony. Religion is a matter of belief or faith. The Constitution of India recognizes the fact how important religion is in the life of people of India and hence provides for the right to freedom of religion under Article 25 to Article 28. The Constitution of India envisages a secular model and provides that every person has the right and freedom to choose and practice his or her religion. In a number of cases, the Apex Court has held that secularism is the basic structure of the Constitution. One of such important case is that of Keshwananda Bharati versus Union of India. We are all very familiar with this case. So, secularism means developing understanding and respect for different religions. It is believed that the word secularism has its origin in late medieval Europe. In 1948, during the Constituent Assembly debate, a demand was made by the K.T. Shah to include the word secular in the preamble to the Constitution. The members of the Assembly, though, agreed to the secular nature of the Constitution, but it was not incorporated in the preamble. Later, in 1976, the Indira Gandhi government enacted the 42nd Amendment Act and the word secular was added to the preamble. The 42nd Amendment Act, also known as the Mini Constitution, is the most comprehensive amendment to the Constitution. In the much disputed Ayodhya case, it was held by the Apex Court that the Constitution postulates equality for all faiths. Through tolerance and mutual coexistence, the secular commitment of our country and its people can be nourished. The 9-judge bench case S.R. Bommai versus Union of India 1994 ruled that secularism is the basic feature of the Constitution of India. It also observed that religion and politics cannot be mixed together. If the state follows unsecular policies and courses of action, that it acts contrary to the constitutional mandate. In a state, all the equals should be treated equally. Religion has no place in the matters of state. Freedom of religion has a fundamental right is guaranteed to all persons in India. But from the point of view of the state, religion, faith and belief are immaterial. Constitutional provisions relating to right of religion are as follows. Article 25, it talks about freedom of conscience and free profession, practice and propagation of religion. Article 26 talks about freedom to manage religious affairs. Article 27 talks about freedom as to payment of taxes for promotion of any particular religion. Article 28 talks about freedom as to attendance at religious institutions or religious worship in certain educational institutions. So Article 25, we'll start with it. Article 25 of the Constitution guarantees freedom of religion to all persons in India. It provides that all persons in India subject to public order, morality, health and other provisions, number 1, are equally entitled to freedom of conscience and number 2, have the right to freely profess, practice and propagate any religion. It further provides that Article 25, it shall not affect any existing law and shall not prevent the state from making any law relating to, number 1, regulation or restriction of any economic, financial, political or any secular activity associated with religious practice. Number 2, providing social welfare and reforms. Number 3, opening of Hindu religious institutions of public character for all the classes and sections of the Hindus. Now the Supreme Court in Tilkayat Shri Govindlalji Maharaj versus State of Rajasthan held in this, the Apex Court held in this case that the test to determine the question in deciding what is integral part of religion is whether it is regarded as integral by the community following that religion or not. So this is the integral part of the, this is the deciding factor. In the very famous case of Bijoy Emmanuel versus State of Kerala, which is also popularly known as the national anthem case, The facts of this case were that three children belonging to a sect worshipped only that particular sect, and they refused to sing the national anthem, Jan Gan Man. According to them, the particular sect, children singing Jan Gan Man was against the tenets of their religious faith, and which did not allow them to sing the national anthem. These children stood up respectfully in silence daily for the national anthem, but refused to sing because of their honest belief in their particular belief. A commission was appointed to inquire about the matter, and in the report, the report of the commission, it stated that these children are law-abiding and did not show any disrespect towards the national anthem. However, the headmistress, under the instruction of Deputy Inspector of Schools, expelled the students. The Supreme Court held in this case that the action of the headmistress of expelling the children from school for not singing national anthem was violative of their freedom of religion. The fundamental rights guaranteed under Article 19, Clause 1, Subclause A, and Article 25, Clause 1 has been infringed. It further held that there is no provision of law which compels or obligates anyone to sing the national anthem. Also, it is also not disrespectful if a person respectfully stands but do not sing the national anthem. In the very famous case of Shaira Bano versus Union of India, talaq-e-biddat, which is also known as triple talaq, a kind of divorce through which a Muslim man could divorce his wife by uttering the this word talaq 3 times. A 5-judge bench of Supreme Court heard the controversial triple talaq case, and the main issue in this case was whether the practice of talaq-e-biddat, that is triple talaq, is a matter of faith to Muslim and whether it is constituent to their personal law. By a 3-2 majority, the court ruled that the practice of talaq-e-biddat is illegal and unconstitutional. The court also held that an injunction would continue to bar the Muslim male from practicing triple talaq till the legislation is enacted for this particular purpose, to which the government formulated the Muslim Women Protection of Rights on Marriage Bill 2017. Later, Muslim Women Protection of Rights on Marriage Ordinance 2018 was passed. As the 2018 ordinance was about to expire, the government formulated a fresh bill in 2019, and an ordinance was passed for the same in 2019, which was approved by the Parliament, and finally the Muslim Women Protection of Rights and Marriage Act, as we know it today, 2019, came into force on July 31st, 2019, with an objective to protect the rights of the married Muslim women and prohibit the Muslim male to divorce the wife by pronouncing talaq. The Supreme Court in noise pollution case has given certain directions to be followed to control noise pollution in the name of religion. Number 1, about firecrackers. The Supreme Court has said that a complete ban on sound emitting firecrackers from 10 p.m. to 6 a.m. About loudspeaker, that the restriction on the beating of drums, tom-tom, blowing of trumpets, or any use of any sound amplifier between 10 p.m. to 6 a.m. except in public emergencies. And generally, a provision shall be made by the state to confiscate and seize loudspeakers and such other sound amplifiers or equipments that create noise beyond the limit prescribed. Now let's talk about Article 26. So Article 26, which is subject to public order, morality and health, it confesses a right on every religious denomination or any section of such religious denomination of establishing and maintaining institutions for religious and charitable purposes, managing its affair with regard to religion, owning and acquiring property which might be movable or immovable, and administering the property in accordance with the law. The word religious denomination is not defined in the Constitution anywhere. The word denomination came into the consideration by the Supreme Court in the case of Commissioner Hindu Religious Endowment Madras versus Shri Lakshmendra Tirth Swaminar of Shri Shirut Mutt. In this case, the meaning of denomination was called out from the Oxford Dictionary, which is a collection of individuals classed together under the same name, a religious sect or a body having a common faith and organization designated by a distinctive name. In the case of Aziz Basha versus Union of India, certain amendments were made in the year in the year 1951 and 1965 to the Aligarh Muslim University Act 1920. These amendments were challenged by the petitioner on the ground that they infringe on the fundamental rights under Article 30 to establish and administer educational institutions, and also on the ground that the rights of the Muslim minority under Article 25, 26, 29 were being violated. It was held by the Supreme Court that prior to 1920, there was nothing that could prevent Muslim minorities from establishing universities. The Aligarh Muslim University was established under the legislation Aligarh Muslim University Act 1920, and therefore cannot claim that the university was established by Muslim community, as it was brought into existence by the central legislation and not by the Muslim minority. Now let's move quickly towards Article 27. Article 27 of the Constitution prevents a person from being compelled to pay any taxes which are meant for the payment of costs incurred for the promotion or maintenance of any religion or religious denomination. In a very famous case of Commissioner Hindu Religious Endowments Madras versus Sri Lakshmendra Tirtha Swaminar, the Madras legislature enacted the Madras Hindu Religious and Charitable Endowment Act 1951, and contributions were levied under the act. It was contended by the petitioner that the contributions levied are taxes and not free, and they are not free, and the state of Madras is not competent to enact such a provision. It was held by the Supreme Court that though the contribution levied was a tax, but the object for which it was levied was the proper administration of religious institutions. Now let's see Article 28. So Article 28 prohibits providing religious instructions in any educational institution that are maintained wholly out of state funds, and the above shall not apply to those educational institutions administered by the states but established under the endowment or trust requiring religious instructions to be imparted in such institution. Any person attending state recognized or state funded educational institutions is not required to take part in religious instructions or attend any workshop conducted in such an institution or premises of such educational institution. In the case of DAV College versus State of Punjab, it is the case of 1971. In this case, Section 4 of Guru Nanak University Act 1969, which provided that the state shall make provisions for the study of life and teachings of Guru Nanak Dev Ji, was questioned and as being violative of Article 28 of the Constitution. The question that arose was that the Guru Nanak University is wholly maintained out of state funds, and Section 4 infringes Article 28. The court rejecting this held that Section 4 provides for the academic study of the life and teachings of Guru Nanak, and this cannot be considered as religious instructions. Further, in the case of Aruna Roy versus Union of India, this is a very famous case and it is of 2002 Supreme Court. In this case, a PIL was filed under Article 32, wherein it was contended by the petitioner that the National Curriculum Framework for School Education, that is NCFSC, which was published by the National Council of Educational Research and Training, that is NCRT, it is violative of the provisions of the Constitution. It was also contended that it was anti-secular and was also without the consultation of the Central Advisory Board of Education, and hence it should be set aside. NCFSC provided education for value development relating to basic human values, social justice, non-violence, self-discipline, compassion, etc. The court ruled that there is no violation of Article 28, and there is also no prohibition to study religious philosophy for having value-based life in a society. So, concluding this video, I would like to say that India is the most diverse country with respect to religion. Being a secular country, it does not have its own religion, and every citizen has the right to choose, practice, propagate, and even change his or her religion. However, these rights are not absolute but subject to certain restrictions provided by the Constitution, and no person in the name of religion can do any act that is opposed to the public policy for creating any kind of disturbance or intolerance among the people of India. So that's it for today. Hope you find this helpful. Thank you.